Good morning, everyone. Thank you very much for tuning in again. And I'd like to apologize for last month. Obviously, I didn't have the voice to be able to continue the broadcast, but certainly you can hear my booming voices back in action. And I'm certainly ready to tackle this most, I would say, popular issue, and an issue where much has been written about marijuana in the workplace and what it means for your workplace. But I think I would say that you don't need to be as concerned as you think you need to be, given the fact that it really is going to come down to treating marijuana in the workplace the same way in which you would treat alcohol. And essentially what you will be doing is you will be linking cannabis in the workplace to alcohol. And that will be your platform from which you will actually be able to govern your workplace as you always have. So hopefully that lends a bit of comfort to those of you who are concerned about it. And believe me, I can understand why. I know that certainly, obviously, there's the provincial legislation, which is in effect, and that actually, in my view, contradicts the federal legislation, which is coming into effect in July of 2018. And again, we don't know when, but obviously the provincial legislation actually has a direct provision saying that no person shall consume cannabis in a workplace within the meaning of the Occupational Health and Safety Act. And as we all know, our workplaces are absolutely ruled by the Ontario Occupational Health and Safety Act. When you look at the definition of workplace in that act, it shows that workplace is any land, premises, location, or thing at, upon, or near where a worker works. So very, very interesting, folks, because you've got a very specific definition that says you are not allowed to consume cannabis in a workplace. That means for social functions, cannabis is not to be consumed in the workplace. Whether it's to be consumed at a social function far outside the workplace is a different story, like in a park. Is what I'm thinking, because of course restaurants have bylaws as well. So we're going to have to unpack this as we go, but there is already that sort of contradiction in the legislation, because obviously if it's legal at a social function, you would want to be able to allow the employee to do that, but the Cannabis Act says no for Ontario. What will happen? Time will only tell. I'd like to start by answering Veronica's question, because Veronica very sweetly waited for this webinar. So thank you very much, Veronica. And thank you for the tip for honey and lemon. It did do the trick. And I do appreciate that, because that is a remedy I use as well. Veronica, as I understood your questions, I'd like to go through them. And certainly if you have follow-up questions, please let me know. I'm going to try and get to as many questions as possible, because I certainly want to provide as many answers as I can within our time limits. Veronica, you said that you're assuming if an organization already has a policy that addresses alcohol, substance abuse, that marijuana would simply be an add-on, and you are absolutely correct. That's exactly what you would do. You will, in fact, add it to your alcohol policy, and you will treat it the same. The second question you had is, if an employee claims to have a legitimate need to use marijuana for medicinal purposes, is the employer entitled to ask for evidence of this? Absolutely, there's no question about it. And of course, as you well know, you're going to put that in your policy. It's going to become part of your policy, if it isn't already, that in fact, the employee, if a legitimate need arises for marijuana use, must in fact disclose that to you and must also provide you with evidence of that need. That evidence, of course, is going to consist of not only the cannabis card up till July 18th, which is the medical card that someone who needs marijuana will use, but also it will be medical evidence that you are entitled to ask for, because you're entitled to understand specifically what it's about. I would also encourage in your policy to ensure that you have the ability to be able to determine how to accommodate if a person needs medical marijuana, in the sense that you would be able to differentiate between the different THC strands. And my understanding is that there are different THC strands that are available, that some may not have the impact that others do, and you're certainly entitled to get information about that and ask the physician whether or not there is an ability to be able to differentiate between one THC strand if it has the same impact as another. And that'll be something that you'll want to take on, certainly if the person comes to you with that need. Now, of course, what you will always be able to do is prohibit someone from actually getting into a safety sensitive position while intoxicated. And that goes not only for alcohol, obviously, but marijuana. You have an absolute right not to have an employee high working with safety equipment or working in a safety sensitive position. And that essentially is known as a bona fide reason for not accommodating an employee. And what you would be able to do in that situation is, while you wouldn't accommodate them in their job, you may be able to find a different position that is something the employee could do in order to be able to fulfill some of your duty to accommodate. Because I want to be clear on this. No employee should be driving a forklift or doing anything with safety sensitive equipment. However, that employee still has the right to be accommodated in a different way if you are able to do so, up to undue hardship. And undue hardship is something that I can tell you we struggle with all the time. In fact, I was instructing at Osgood yesterday for the basic HR program, and I can tell you that we were discussing the issue of undue hardship. And as is very expected, everyone wants to know, is there some sort of legal test for that? And unfortunately, there's no legal definition, but there are factors that are considered. And in order to be able to prove undue hardship, you would have to show that costs would be unduly a hardship for the organization in order to be able to accommodate someone. Likewise, if you were able to explain that you had incredible safety concerns, and if your workplace is only safety and you can't accommodate the employee in any way, that would be a very legitimate reason not to be able to accommodate, and would be a bona fide reason for that. You also have to be able to explain whether or not there are any other factors that are relevant that would put the organization at risk or would in fact impact on it so that it would cause the organization undue hardship. It's a very tough test to meet, but it can be met if in fact you're able to show a tribunal or a court that, if in fact you're asked to accommodate and it would cause you undue hardship. Moving on to the questions you've asked, Veronica. If we consider that smokers are given the flexibility to leave their desk workspace for a smoke break, if there is a legitimate need to smoke marijuana for medicinal purposes while at work, would this fall under the smoke break parameters? That's going to be tricky given the fact that the Occupational Health and Safety Act and the Ontario Cannabis Act say that no person shall consume cannabis in a workplace within the meaning of the Occupational Health and Safety Act. Now, obviously, that's going to create a bit of an issue for you, because if someone needs a legitimate need to smoke marijuana and you need to accommodate that, we're going to have to find a different way to do that. Maybe it's after hours, but it's not at the workplace. There's going to be different sort of ways to look at that, but no, you're not going to be able to do that pursuant to the legislation. If you've asked, what measures can the employer take to protect other workers from an employee who is deemed to be impaired? And I would say, again, the same thing you would do with an employee who is found to be inebriated at work or intoxicated. You would put them in a cab immediately, make sure they are safely taken away to their homes by cab, and then you would have a discussion with them the next day to determine what happened, and then you would make a decision based on that. Now, you may be dealing with someone who has an alcohol problem or a substance abuse problem, in which case, again, you're going to have a duty to accommodate, and you're going to have to essentially review what the circumstances are with the employee and work out what would be the best accommodation in that particular scenario. Veronica, you've also asked in respect of if through the recruitment process, an employer becomes aware that a prospective employee is a user of marijuana, could it be construed as discrimination if the employer chooses not to extend employment because of the use of this substance? Yes, it could, unless in fact the employer has a bona fide reason for it. And again, I would say if you're hiring someone to drive a forklift and they disclose that they have that actual need to have medical marijuana, certainly it doesn't sound like that person would be a good fit as a result, and you would have a bona fide reason not to hire them. But I think it's first of all, I would advise not to ask these questions. This would only be if the employee volunteered it, because you need to ensure that any questions you ask during recruitment are not something that would be seen as discriminatory against an employee in a situation where you could be seen to be discriminating. And a very simple example of that is not to ask about whether the employee has a family or has children, because that immediately could be perceived as an issue of family status. However, in respect of, asking whether or not the employee is able to do the job, you're certainly able to ask that question. But you can't probe in terms of whether the employee has a disability or anything of that nature. It would only be if the employee raised it himself or herself. The next question I understand from Veronica, are there any bona fide reasons, circumstances that an employer could use to ban the use of marijuana from their workplace? I believe I've already answered that, just in respect of the safety concerns. If you're asking about, obviously, medical marijuana, if you're asking about marijuana from the workplace, you would basically ban it under the same guise as alcohol. No employee, and this would be in your policy, has the right to be intoxicated in the workplace. It's as simple as that. And if the employee breaches that, then you have an employee who's breached the policy, and you can take appropriate disciplinary measures. Now, in respect of that, I think it's very, very important that the employers know out there what the policy is going to contain. So you're going to have your prohibitions in the policy, prohibiting drug and alcohol use in the workplace, requiring disclosure of prescription drugs or medical marijuana. And if there is a prescription, the request that both the employer and the employee work together to form the best accommodation possible for the employee so that it meets both needs. You're going to want to ensure you've got reporting mechanisms so that you've got an ability to have the employees know that they go through one process, and they need to know what they need to provide, and you need to know what you can ask for. I'm sure everyone already knows you can never ever ask for the actual diagnosis that an employee has. You are not entitled to that information as an employer. Employees, please know you do not have to provide that to the employer. However, employers are entitled to ask about prognosis, meaning when is the employee going to come back to work, and what, if any, restrictions or limitations the employee may have in doing the job. That goes back to one of my first points, which is to determine what kind of THC levels you're dealing with and whether or not there are a lesser potent THC level that will do the same job according to the doctor, not you, the doctor, to ensure that the doctor knows that what you want is for the employee to be able to perform in the job, but obviously not be impaired in doing so. And that is possible, but you have to work with the doctor for that. You can't possibly make up your own conclusion or mind on that. So hopefully that's clear. Excuse me. You also, of course, in your policy want to ensure that you have the consequences of a breach of that policy. What's a policy without consequences if it's breached? You need to be very, very clear that there will be either disciplinary action taken for the employee who breaches that policy, or alternatively, that if it is breached in such a way that you deem something to be of such a significant nature, you have the right to terminate that employee either with or without cause. And again, folks, there are no sort of tailor-made solutions or one-size-fits-all solutions. Each and every case has to be examined on its own individual merits. That is the nature of employment law. That is why those individuals who say, well, you know, reasonable notice, for example, should be predicted with mathematical precision. Absolutely not. Every employee is different. Every employee has different needs and different situations and circumstances, all of which need to be considered by both the employer and the employee. I want to spend some time on the employee because I think employees need to also appreciate that in the accommodation process, they have absolute duties to fulfill as well as the employer. And that is to be forthcoming with the employer, to provide the employer with the ability to understand what is happening, and to be very forthcoming about how they can be accommodated and work with the employer. Realize, employees, for many small businesses, it's very, very difficult on employers to be able to accommodate employees, and they want to do so with dignity and respect because employees deserve that. And it's not the case that they don't want that, but it is extremely difficult to know what to do if the employee is not working with them. And employees, you can be faulted for that if you don't work with your employers on that. So know that because it's very important in the whole process. Excuse me. I'd also like to address a question that came in from another viewer, and specifically, I'd like to address it because it was all about how we go about creating a marijuana policy. And I'm certainly very hopeful, based on what I've already said, that those are going to give you specific tools. But I do want to say, I hope you already have policies in place because, folks, the policy is the bedrock of your organization. It's from the policy that you're able to direct workers to do things. And likewise, employees are able to gain the knowledge as to how they're able to work in the workplace. Marijuana is simply another extension of it. So I do hope that that's now clear. Certainly, I know that another question that came in, these all came in the last month, so thank you very much for sending them in, and I'm very happy to know that we're able to answer as many as possible. One person asked me about whether random drug tests are permissible, and the answer to that is no. I know of the TTC case. I know that that case was all about the fact that the TTC asked for an injunction, asking that they could actually randomly drug test their employees, and that was granted. And the reason it was granted is because it was in the public interest to do so. So if you are an organization where it's in the public interest of you to do so, or a safety sensitive position where every single position in the workplace is safety sensitive, you may be able to do that as a random drug test. But I'm telling you, in respect of that, we don't have the same laws as the US. Canada is different and does not allow that. This particular case was very, very focused on the issue of the Canadian and Toronto safety. So it was looking at the safety of Toronto and saying, do we want to make sure that our TTC drivers who drive us on subways and streetcars and buses are drug-free? And that is why the court I think it was the arbitrator, came back and said, yes, we're going to grant that under those circumstances. So if you fit into that circumstance, then you may have the right to do that, but always make sure you consult your lawyer before any of that occurs. Excuse me. I'm asked about, and I think this is a very good question. One of the other questions that came in was, Natalie, I'm concerned that my employee is abusing marijuana in the workplace, what kinds of steps should I take? And I want to answer this so that it's very, very clear. Obviously, from a legal perspective, we know that drug and alcohol addiction is in fact a disability. We know that. The law is clear on that. And the law is equally clear on the fact that we have a duty to accommodate. But approaching an employee with this is a very difficult thing to do. It's difficult because you have to end up saying something to an employee that you don't necessarily want to get into, and you don't want to obviously approach an employee and embarrass the employee and put the employee in a position where they feel that you're ganging up on them. But at the same time, you have an obligation to the employee. And if you have some suspicion that your employee is abusing alcohol or abusing drugs, the first thing I would recommend is taking that employee into a closed door meeting, sitting that employee down with a cup of coffee or a glass of water, and asking that employee about it by saying, we're noticing that this is really, your performance is really starting to slide. And it's looking like you're coming in with, very red eyes and slurred speech. And it's happening on a very regular basis. And I can tell you right now that I'm very concerned about that. Is there something you think we need to know? That's the first thing. Then you let the employee speak to you about it, or you take the next step and say, do you have an abuse problem? Are you abusing drugs or alcohol? And I can't stress to you how often when this is done that the employee will almost feel unburdened and be able to speak to you about it and perhaps really want to get help. And then you can actually help your employee in any way you can by being able to suggest potentially drug rehabilitation centers, You may be able to suggest programs. There are outplacement, or not outplacement, but pardon me, you don't have to necessarily stay in facilities, but there are facilities where you can attend them by day. And you as the employer do have that duty. So I know it's a very difficult conversation, but it's one that you do need to have, because if you become aware of something and you don't do anything about it, then you could potentially be liable, and you don't want to be in that position. Also, just from a humanistic perspective, you want to help that person. So I certainly think, you know, I'm proud to say that the employers that I represent and have always represented are employers that are compassionate and fair and reasonable. And I think you want to apply those same standards in this setting, but no, you do so very cautiously, but very, very discreetly, so that that employee is not embarrassed or humiliated in any way in the workplace. Okay, I think we have time for one more question. And this one came in from, I'm just trying to think. And I think I've already gone over this, but I'm going to say, specifically, it's about what information should employers know, and who should they contact if they need information on an employee's accommodation needs? And I think that's a great question, because of course, we know that obviously the obvious answer is the doctor. So we're going to take our cue from the doctor. But I think it's incumbent upon employers, particularly in preparing for the legalization of marijuana, to be able to research as much as possible what kinds of things are out there. And I think, you know, everybody seems to do Google searches these days. That's a good way to do it. And there are many, many organizations that deal with trying to accommodate employees for medical marijuana, who are more than happy to spend time with you in terms of different ways to be able to do that. I know there's one organization out there that, you know, actually, if there was a need to inhale marijuana, there was a mist that was supplied that would actually completely stop the smell of marijuana in the workplace, not in the workplace, sorry, but outside of it. And that would be something that, you know, organizations that are, I think, all over are willing to help employers out with. So certainly, I think that employers do bear that burden of going out and doing as much research as possible and learning about it. Anyways, we have reached our time for today. I'd like to thank everyone very, very much for tuning in. Again, apologies for last month, but certainly next month we will have another webinar at the same time, Wednesdays at 11 o'clock. And I will certainly ensure that your topic is known prior to that. I wish you all a great rest of the week. And certainly for those of you who are celebrating religious holidays and Easter, I wish you all a very happy holiday and a great start to the month of April. Certainly hopeful that we'll get warmer weather and continue to have that going forward. Thank you, everyone. Have a great day.